All right, Judge Sofidi. So our next video is in regards to tips and tricks that we would like the private bar and pro se litigants to take in relation to the 308th Family District Court. So first discussion or point of discussion, I want to address our motions for continuances. I want to first thank all of the private bar because the motion for continuance filing has been a lot better than when we first took the bench, which I absolutely appreciate, being a motion litigant or litigator in the past. So I do appreciate that. A little bit of, or a few tips that I would give that the court likes to see, or through practice we like to see, is your motion is more likely to get granted if it's more specific. What I mean by that is if you file a generic motion for continuance that is taken from ProDoc and is not verified, it's not likely to lead to a trial date to be reset or a continuance to be granted. If you explain to the court why you need a reset and you're candid about why you need a reset, you're likely to receive and have that motion granted, even before the date of trial. So like we discussed before, if you have an agreed motion for continuance and you do it before trial date, before the morning of the trial docket, and you submit it under the signing box, you're likely to have it granted beforehand, and you don't have to make an appearance the date of trial. Do you have another topic you'd like to address?
Yes. One of my biggest pet peeves is when I'm people showing up on my uncontested docket when they are scheduled on the submission docket. Submission docket is different from the uncontested docket, and the submission docket is heard by submission. So please do not show up on the uncontested docket expecting to be heard when your setting is on the submission docket.
I think what could help in relation to that is if you have a motion to be considered on the submission docket and you're drafting your notice for that motion to be considered on the submission docket, try to make sure you don't put submission or motion for appointment of amicus scheduled on February 1st, 2022 by submission in the Harris County District Court located at 201 Caroline. When you put the entire court and the entire address, and some people even include meeting IDs, it creates a confusion as to whether this is truly by submission or somebody's required to appear on a Zoom hearing, or lastly, possibly appear in person. So if your notices are a bit more clear that it's truly by submission, will be considered by submission. If you want a response to be considered, file a response no later than X date. It will possibly alleviate confusion as to where you have to be or how the motion will be considered.
Another issue that I see often is people scheduling hearings before their filings have been accepted and placed in the court's file. So when you go online and you schedule a hearing, we can't set the hearing because no motion or no petition is in the court's file, and we can't set something that does not yet exist. So please wait until the pleadings have been accepted by the clerk before you go online and schedule the hearings. This will prevent you from having me cancel your setting on multiple occasions because I don't see what documents you have filed.
And I can appreciate that either an attorney or paralegal or a person probably is working immediately and you're just on task. You file something and then you immediately go and schedule it, which makes absolute sense in chronological order. But from our end, so that you know you schedule it, you want us to sign it or review it, but there's nothing in the file to review. So then we have to touch that file several times. similar to lawyers in practice. You guys have an insane amount of cases with a lot of clients. We do have a lot of cases. We do have a lot of filings and a lot of orders we have to review daily. So this prevents us from having to touch a specific case file 4 to 5 times a day. Another topic in regards to continuances is I've had motions, agreed motions for continuances that are granted prior to the date of trial based on an agreed order, and I happen to set it on a trial date that somebody or everybody is not available. That can certainly be a problem. So a suggestion could be if in your motion for continuance, you can identify dates that everyone's available. That way the court can either set a pref setting or set it on a general trial docket that everybody's available. That's very helpful for us. We can't read you all's mind and know that there's a graduation happening on that day or a vacation happening on that day, unless of course there's a vacation letter. But sometimes people take vacations not during their vacation letter designations, which is natural and okay, but we can't know exactly that's happening unless of course it's identified in the motion. You can also identify dates you don't want us to set it. Maybe you already have a jury trial pref set or a bench trial pref set, and that specific trial docket Tuesday is not going to work for you. So just state that in your motion. We agree to continue the trial date, Your Honor, but we're not available on the following dates. That works as well.
You mentioned preferential settings, and I do want to state this. If you have a preferential setting that you scheduled on the court's website and you need to pass that setting or you want to pass that setting, please, please, please cancel the setting online so that spot can be opened up for other people. Sometimes, rightfully so, you call the clerk or you email the clerk and say, hey, I want to pass my setting for next week. And the clerks pass it in deeds, but that schedule or that block of time is still blocked off on the court's calendar, and so nobody else can use that time.
And it's the online scheduling system that everybody has access to and they use to schedule settings in the 308. So if your pref setting that you scheduled is still blocked out on our online calendar, it prevents other people from using that block time. So as everybody has experienced, it could potentially be difficult to obtain a pref setting for 4 hours. But if somebody settles, there's an MSA, or even just a want to reset that pref setting, it provides other parties an opportunity to go before the court. So it's extremely important that you cancel or reset online.
And I do want to say the clerks try their hardest to tell us when something's been passed, but sometimes things fall through the cracks, and that's why we're just asking you to do that extra step.
I agree. And also, at times we only have one clerk. At times that clerk is on the phone nonstop, phone after phone call, possibly 20 calls before they have an opportunity to take a break from their phone calls to address us or advise us of what you just emailed them or told them on the phone. So it may be easier to just cancel it online if you have that ability because you scheduled it online. If you scheduled a pref setting through me, if you were at a trial docket with me or a TRO docket with Judge Salfidi, and we gave you a pref setting, you didn't schedule it, then we understand you can't cancel it online, but please contact the court and pass the setting or reset the setting. Because again, that'll provide us an opportunity to unblock it online and allow somebody else to schedule their hearing. Any other topics?
Speaking of online settings and preferential settings, preferential, especially temporary orders hearings, you see it on the court's website. I believe we have various times from 45 minutes up to 3 hours. Those are for when both parties have made an appearance and mediation has occurred or at least scheduled. Okay, so if this is your first setting and the respondent has not been served, please do not schedule one of those preferential temporary orders hearings. Please schedule your setting on the virtual TRO docket. Even if you are just asking for temporary orders and not a TRO, just schedule it on that virtual TRO docket.
Another topic or something that everybody should take note of is please check the docket entries made connected to that cause number. If you scheduled something under the signing box, if you scheduled something under the submission box, sometimes you call the clerk to have a specific order placed for signature and you're wondering what happened or why it hasn't been signed. A lot of times, a large percentage of times, you will find the answer on the docket entry. It's really important that attorneys, paralegals, office staff, pro se litigants learn where to locate the docket entries. It'll provide you the answer to a lot of your questions. What are you missing? What documents were not filed or accepted or imaged? Why a motion was denied, potentially, why an order wasn't signed. It can provide a lot of answers without having to make you contact a clerk or email a coordinator to try to find that answer. Any other topics, Judge Selfie, that maybe you have?
That is all I think I had written down. If there's nothing else, I appreciate everybody watching this.
Yes, and if you have other questions or comments in regards to the topics we addressed, we encourage you to contact the 308 clerks. Right now, we do have our lead clerk that has been working tirelessly to help each of you and serve you, as well as our court coordinator, Ms. Beard, that's been trying to assist our clerk while our assistant clerk is out. So their contact information and email address is located on the court's website. You can always email them and contact them. I know they try their best. Please extend some grace to them and have patience with them. They answer a lot of emails every day. I don't want to misquote it, but I promise you it's over 200 emails daily to make sure that each of you are informed and feel like your questions are being answered as timely as possible. So again, thank you for your time, your patience through this entire time, and we hope you have a wonderful weekend.